Welcome to the Top Texas Lawyers Podcast. This podcast is brought to you by the law firm of Abercrombie and Sanchez, PLLC. You can find us on the internet at astxlegal.com or by calling 1-888-981-7509. Your hosts are Bryan Abercrombie and Samuel Sanchez. Bryan has been practicing law for 18 years and is board certified by the Texas Board of Legal Specialization in the area of family law. Sam has been practicing for 13 years, is licensed in both Texas and Florida, and is a certified mediator. This podcast is for informational purposes only, and all views are the opinion of the hosts. It is not designed to provide legal advice for your particular legal matter, and it should not replace the advice of competent counsel. Welcome, and we hope you enjoy the Top Texas Lawyers Podcast.
Well, hello, everyone, and welcome back to Top Texas Lawyers Podcast. This is Samuel Sanchez. I'm your host today. My co-host and partner in crime, Bryan Abercrombie, is on the horn as well.
Hello, hello.
Yes, you are the cream to my Oreo cookie there, Bryan. I'm glad to have you. You make everything taste better. So
yes, at least as long as you say I'm not the double stuffed cream to the Oreo cookie.
No, you're the brilliant side of that equation. We're back today to talk about the part 4 of our 5-part series on divorce. And this is really going to be mediation and potential informal settlement options that may exist as we encounter the divorce process. But before we get to that, quick shout to what's in the news, Bryan. In the news corner, you got anything?
Well, I know that the Jay Cutler and Cutler-Cavallari divorce is running hot and heavy right now. I know that's been dominating the news cycle. It's kind of unfortunate, I guess, when people get divorced whenever there's very little in the news cycle other than quarantine mania that we got going on right now. It just makes the pop culture gossip just that much more, huh?
Yeah, absolutely. And obviously this divorce is going to be played out on the press quite a bit. But the interesting part, and I think this is something to kind of make note of, is last report I saw, they actually reached an agreement as to the children issues. So they've settled those portions of their divorce. So what remains at issue right now is the property division. And a lot of people don't realize that you can actually do that in divorces, that you can actually narrow the field, or the scope of what is at issue by doing something like that, reaching an agreement either on the property issue or the children issue, if you have both of them going on, before you even get to the end of the divorce. Oh,
definitely. And you're also seeing some of the kind of the salacious stuff playing out in the media that, Jay wasn't supportive of the off camera on the TV show, or that he was, difficult to deal with on the TV show and mean to her. And, you just see all the tabloid stuff coming out. Whether that's true or not, I don't know. But, I think that's probably going to have an impact in the property division, because obviously that television show is going to be probably for whatever it is, it's at least some portion of lucrative marital property. It's definitely, entertainment, obviously, but it's also, a lucrative, really business venture for both of them, really. So I know that's going to be played out.
Oh, for sure. You're absolutely correct. And I mean, I know one of the things that they've really kind of focused in on and obviously can come up in a divorce when you have high wealth assets or individuals. Kristen's camp is out there, using the press saying, well, he was unsupportive, he was lazy, he was unmotivated, he didn't, contribute, and maybe he even acted detrimentally. Remember when he came out of retirement to go play for the Dolphins? Now they're asserting that, well, he cost us a bunch of money because he dropped out of the show. And so what that is, for those who are kind of seeing this as a spectacle from the legal field, that's all positioning, that's all jockeying, that's all smart lawyering. Sure. Understanding that, you're really trying to put people in a position to kind of take sides. And the more you kind of put out your version, your spin on information, and this happens in and out of the courtroom, the more likely it is that, sometimes you're going to have people sway or come to the middle, which is what we're going to talk about today.
I mean, you also have, and to an extent, I'm not saying they don't work hard or anything like that, but to an extent, you have celebrity folks who don't necessarily live in the real world where we all live. And, so you've got, the potential things coming out of this. If you can spin up a story of heartbreak and, recovery and different things like that, I mean, this can lead to lucrative book deals. It can lead to, financial implications, specifically on the part of Kristen Cavallari, because I think she's a very, likable, TV personality. I think her camp, like you said, is, kind of strategizing and kind of putting her in the best position to be successful, which they should be doing. Jay's camp is kind of doing the same thing when they say that he, hey, he was the primary dad and he was doing the majority of the stuff and this and that. So, I don't know that Jay cares as much about, what's said in Hollywood gossip circles as maybe Kristen does. But, they're kind of posturing themselves for life after the divorce and where they're going to take their careers after this.
Oh yeah, you're absolutely right, Brian. And in that too, let's just talk about this process because it really ties in perfectly with our subject today. So you're in a divorce, and maybe you're not a superstar, but you've got, everything you've worked for in your life that's at stake, including your children, your family, and how that looks like going forward. You've participated in the discovery process, right, which we talked about in our last podcast about getting information and gathering kind of the bricks to be able to build the new house. And now you're trying to figure out where do we go from here. So at this point, Brian, like, how do you kind of give clients insight about where do we go next?
Well, at least in my county and the counties where I primarily operate, and I think in the majority of the counties that you operate in, the court is going to require you to go to what's called a mediation before you have a final knockdown, drag out, World War III kind of thing at the courthouse. So a mediation is quite simply, it's an opportunity, it's informal. You usually go to a mediator's office. A mediator is basically a neutral third party that will go between the two of you. You'll be in one room with your lawyer, and your spouse will be in the other room with their lawyer. And the mediator will go back and forth and try to kind of broker a settlement and try to work both parties into areas where they can settle. Now the settlement looks like it can go a couple of different ways, or a number of different ways rather. A settlement can be full. You settle every issue, whether it be child, property, whatever else is on the table. You can settle everything. You could settle nothing, and everybody just walks away, and you're free to go to court. Or you can settle some things, like a partial settlement. Maybe you like Jay and Kristen. Maybe you settle all the kids stuff, but you still have the property stuff on the table. Or you settle all the property stuff and you still got the kids stuff on the table. There's partial settlements that happen all the time, and at the very least, it gives you some insight as to what the other party is going to try to argue and what they're going to try to go for at trial. Now, the bulk of the time in mediation is very successful, and you don't end up in a knockdown, drag out at the courthouse, but sometimes you do. So you got to be ready for both. The good thing about mediation is it's a completely confidential process. So nothing that's said at the mediation can be brought up in court. And nothing, the court can't ever know how close you are to settling, or how close you're not to settling, or how reasonable or unreasonable you're willing to be. So the good thing about mediation is it's a completely confidential process, and it's non-binding unless and until you sign your name on that dotted line.
So that's a great point that you raised there, Brian, because I've, obviously clients a lot of times will come in and say, we're going to try to settle it. I don't know if you have this. I always tell people if I had a quarter for every time I heard this statement, I could have retired a long time ago.
Yes.
It's that, don't worry, we're going to reach an agreement. Well, this is really what we're talking about. Do a lot of people reach an agreement? They do. Do you have to go to formal mediation to have that done? No, there's an informal process that you can use as well. But the chief advantage, in my opinion, at least, to mediation is that if you reach an agreement, it is binding and irrevocable. Right?
Yes.
There's no crawfishing on the deal. You can't wake up the next day and say, by God, I can't believe I agreed to that. I want out of it.
No buyer's remorse.
No, and what people need to understand, at least in Texas, Florida is a little different, but I would tell you in Texas, is that it is an extremely powerful process. What I mean by that is once you reach an agreement, setting mediated settlement agreements aside is very complicated. Has that been your experience too, Brian?
I've been practicing for almost 20 years, and I've never gotten one set aside. So
yes. I mean, it's very, very narrow types of fact issues that would present themselves to afford you the opportunity to do that. Whereas in an informal settlement agreement, because clients ask this all the time, well, you know what, maybe I don't want to pay the expense potentially of having to go to a mediator's office, and can't we do this informally? You can. There's what's called a Rule 11 agreement. It's basically a civil rule that affords parties the opportunity to settle issues And it's like contract law, right? At the heart of family law is contract law. And when we're dealing about property, even though we're talking about kids, I would tell you kids in Texas are considered chattel, right? It's a form of property. We have an ownership interest in them. And so when you reach a binding agreement outside of court, it's still an agreement, but it's contract law. And when you talk about contract law, the only remedy typically for breach of contract is what, Bryan?
That would be an enforcement suit.
Right. And that is only going to typically get you money damages, right? So if you look at it and you say, well, but I really wanted that piece of art, most of the time in that type of an agreement, you're not going to get specific performance. You might get attorney's fees, but in a mediated settlement agreement, it's much more powerful in the effect of what that binding agreement is. Does it keep both parties to those specific terms? It absolutely does. So when you're talking to your attorney and you're kind of formulating a plan about how the case is going to go, I always tell clients this is a great opportunity, and it's probably going to be the only opportunity that a client will have to be the captain of the ship. The rest of the time, they're the first mate. They take a lot of orders and they do a lot of work. Their attorney is the captain. But at mediation, they get to be the captain. And what I find so powerful and unique about mediation is the creativity that you can employ those meetings.
Yes, and I would also tell you that a Rule 11 agreement, they sound good, or a cocktail napkin agreement, or something you draw up at the kitchen table that sounds good and everything like that. And sometimes it does work, but the big difference between the two of them is, I think, peace of mind. So what I mean by that is a mediated settlement agreement is irrevocable. You cannot back out. A Rule 11 agreement, a kitchen table agreement, a cocktail napkin agreement, whatever you want to call it, you can walk away from that at any time. You can file a revocation of a Rule 11 agreement and you're out of the deal. So, a mediated settlement agreement gives you the peace of mind of it is done. These things are done. They're done forever. And, kid stuff's not completely done forever, but I mean, it's harder to overturn it. But property stuff, once you sign that mediated settlement agreement, it is done for all time.
Yeah, that's a tremendous advantage, especially if you're wanting to make sure things are complete, right? You're going to be able to move back. Because let's say you are able to reach an agreement, and let's just talk about it informally. Can it be changed from an informal agreement into a final decree of divorce? Yeah, absolutely. Once it's a decree of divorce, is it irrevocable and binding? Absolutely. But we're talking about the window in between where there's risk. In a mediated settlement agreement, what about that, Bryan? You have a mediated settlement agreement, but you don't have an order, and somebody wants to crawfish or doesn't want to do it. What are your avenues then?
Well, what you can do is you can prepare a court order that looks like that mediated settlement agreement, that contains the terms and conditions of that mediated settlement agreement, and you can submit that to the judge along with a motion and ask the judge to sign off on that because you have a binding agreement. And based on the Supreme Court case that came down a number of years ago, that judge has to sign that decree. If that decree conforms to the mediated settlement agreement and they're identical, then it follows the right form, then that judge has no alternative but to sign that decree, and that's the end of the case. So you're the other side, maybe crawfishing on the deal, but that's it.
Yeah, I used to have a contracts professor who was a really famous, jurist in Texas, Dr. Spurlock, and I know you know him. And he used to have this whole little catchphrase about boom, you got a contract. And so, this is like a mediated someone is that big boom. It's like boom, the door is closed, and all that's left is really the ancillary details. There's no going back and renegotiating that. It's done. And now, so that's a tremendous advantage.
Now, very, very good lawyers, go in and try to get these things set aside all the time on behalf of clients. But I'm going to tell you that it's very, very difficult. You have to have, essentially fraud on the part of the mediator. I mean, there's some really, really outlandish kind of way out of the box things that have to happen if you're going to get one of those things set aside.
Yeah, and so like when you talk to clients, Bryan, and I'll tell you kind of from my perspective, I always tell clients, not only do you get to be a captain, so that means you can be creative. We can do things that normally don't happen in the courtroom in mediation. Right. What I mean by that is that when I say creativity, we could, in the courts are bound by precedent and law. But in mediation, we can do things that maybe don't have a basis in law, but as long as they don't violate the law, then you can do it. I'll give you a clean example. In Texas, we have what's called the standard possession schedule, right? This is for custody purposes. We've talked about it before in previous podcasts where one parent is going to get the majority of time compared to the other parent. But let's say you're in mediation and you say, well, we don't want to do that. What we really want to do is we want a custom possession schedule that, goes 2, 2, 5, 6, 3, 2, 1, 8. Now, to most people, that sounds ridiculous. But for these two individuals, it works. It works for their life based on their schedules. Can you do something like that in mediation, or are you bound to the statute that requires this first, third, and fifth possession schedule that's tied to a standard possession schedule, right?
No, that's an excellent point. I mean, you can do whatever you want. Whatever two people can agree to in mediation, you guys can do within the realms of, it being legal. Which is a good kind of segue to the next part of this thing, which is how to prepare for mediation. Because mediation, a judge is never going to know you. The judge is never going to tuck your kids in at night. The judge is never going to know your kids. Yet you're asking these people, who are human beings, to make decisions on your life with a very, very limited amount of information on your life. I mean, the best thing about mediation is that the two people that have the most to win or lose in the process are the ones making the decision. So it allows you the opportunity that, hey, maybe I'm a firefighter and my wife's a nurse or my wife's a flight attendant or something like that. And we don't have a traditional 9 to 5 type of schedule. So we need to do something different. So that standard possession schedule is not going to work for us. So it affords you the opportunity to be very creative, especially when it comes to kid stuff. And I've done, if I've done 500 mediations, I've maybe done 500 different types of agreements. They're not all, you don't have to be cookie cutter in the thing. That's the good thing. That's why you want to go into this thing prepared.
Oh, without question, Bryan, the most important piece, and I think a lot of, lawyers who participate in this process sometimes overlook this with their clients. Because if you're going to prepare for trial, I promise you, every lawyer in the world gets ramped up for trial. And if they don't, you might want to consider who you chose as your lawyer. But
Sure.
But most lawyers invest a tremendous amount of time and energy getting prepared for trial. However, not every lawyer, but a good lawyer will always spend a substantial amount of time and energy preparing for mediation, because what we just talked about. So for you to be creative, what I always tell clients, in order for us to be creative on the day of mediation, you have to think of it almost like a chess game, because you are playing chess with somebody who's in another room. You don't get to see their body expressions. You don't get to see if they get mad or they get happy, based on an offer that's made or, terms that you're proposing. You're using the mediator as a go-between. And that mediator, the power that mediator brings to the table in that situation is that they get to know everybody's dark secrets, right? They get to know everybody's strategy and plans and what they're willing to give and what they're not, because they can't tell that in the other room unless that party authorizes them to do that. But in order to properly utilize that as a good tool to reach an amicable settlement, lawyers and clients have to be very well prepared about a case, understand the dynamics, understand what potentially are hot buttons in the other room, how to push them, how to draw off, how to bring people to the side to help a mediator reach an agreement.
And it's the preparation for that mediation is that time to go down a couple of those rabbit trails and decide, okay, well, this is an important thing that we need to worry about, and this is not an important thing that they're going to try to throw at us that we can kind of shuffle to the side or have a response for. It's an opportunity rather than blowing up based on the claims that they're making at the mediation. This gives you an opportunity to kind of war game or game plan, how you're gonna tackle each scenario that comes up and work towards a kind of a creative solution.
Yeah, without a doubt. It's a little Sun Tzu, the art of war. In that, there was one real kind of piece of that book that always stuck with me. And he's basically advising, he says, in order to properly defeat an enemy, you must always understand your enemy. And I think in this situation, not that you're considering each other like enemies, but you are adversaries. A lot of times you don't
You're on the other side of the table.
Yeah, you don't have the same interests. You don't have the same desired outcomes. And so you really have to have clear goals and objectives when you get into mediation. And you have to have contingencies planned, because I think like young lawyers that I've talked to in the past that I've helped prepare for mediation, that's one of the things that I think they always struggle with is they'll spend a lot of time and energy really knowing the case, knowing the issues, but then they see it black and white. And where they miss out kind of and struggle on that day of mediation, and sometimes maybe don't even settle because of it, is that they miss the shades of gray. They miss the opportunity to kind of think contingencies early on, because that will help facilitate the day, because it's still a finite period of time. I'm not saying that, look, most mediations are, you can do a half day mediation. Sometimes you may do a full day mediation. And sometimes you even maybe do multiple day mediations. But in that, you're doing your client a disservice. And as a client, you're doing yourself a disservice by not preparing yourself for contingencies, right? Being able to think through potentially, if like this were to come up, things that I don't necessarily believe would be an issue, what potentially could be, and what are the alternatives that I could propose.
The other thing would be, this gives you an opportunity to really dive into what the other side's contingencies are and what their hot button issues are and what their goals are, so that you can really wrap your head around where they're coming from, so that you either know how to respond, or that you know where there's common ground that can be, we're not trying to put together the Geneva Peace Accords here, and most of the time, sometimes we are, but for the most part, I mean, there is, despite how much two people dislike each other when they're going through this process, there is a lot of times some common ground between the two of them and their positions and what they would like to see. I mean, obviously nobody wants harm to come to their children, for example. And so you start there and you start working towards what is going to be a scenario where there's no, harm, lessen the impact of harm to the children. Now, you may have different viewpoints of what you think is best for kids, but I mean, you can start agreeing on little things, and then those a lot of times work into big things. But the good point about it is it allows you to kind of understand at least what the goals of the other side are, so that in your preparation and in your trial.
Yeah, and one of the new wrinkles that I would just advise clients that are listening to this, or individuals who are listening to this and thinking about, like, well, maybe mediation sounds like something that would be a great alternative for me to be able to resolve things with my significant other. You just got to remember, like, COVID has really changed substantially that process. And so where before, mediation, and it will be hopefully in the future again soon, you're really showing up in a room, like Bryan said, you and your attorney are in one room, the opposing party and their attorney are in the other room, the mediator is bouncing between the two. But as it stands right now, they're doing these via Zoom. Now, that sounds like it would be, substantially different. And it is, I will tell you, like, not quite the boiler, the pot that you get tossed into and that boiler pressure that you feel being in the same location. But I would tell you, it's still the same process, because what they will do is they'll basically set up a Zoom meeting or a Skype meeting room, and then they will partition those individuals off. So you're still not seeing the other side. You're not participating in those conversations, but the mediator is actually bouncing through that electronically, which is new. It's a new wrinkle. So the ever-changing landscape of the law.
Well, I would also say that when you're in that room at mediation, or when you're on Zoom, or however you're doing the mediation, please understand that the role of the mediator is to try to get to a resolution. So the mediator is going to come in there in the room and is probably going to tell you the weak points of your case, and some things you maybe don't want to hear, and some things that are difficult to hear, and some things that are upsetting to hear. And what you have to do is be ready for that. And you have to understand that they're doing the same thing in the other room, because I've heard it one time, I've heard it 100, that clients come out, that mediator didn't like me. That mediator just took her side and didn't listen to me at all. And then the other person walks out of the room and says, that mediator disliked me. They took the other side. They didn't listen to me at all. So you really have to be prepared for what the mediator's role is. The mediator's role is to work both sides towards the middle. And that sometimes means that they're going to tell you stuff that you don't necessarily like, or you don't necessarily want to hear, because the lawyer's role and the mediator's role are very different. The lawyer's there to advocate for you, but the mediator's there to try to see kind of both sides of the case, and maybe tell you, hey, there might be some weak points here. I'm not the judge, but there might be some weak points here, and there might be a chink in your suit of armor over here. And, you may need to look at this and just evaluate the risk and evaluate the potential liability and all that kind of stuff. So I would tell you that the mediator's role is decidedly different than what your attorney's role is going to be in that process. And please understand that it's not the attorney's job to stand up and finger wag and pound the desk and yell and scream and make a big spectacle in front of the mediator. That's not really the time for that. The time for that is down at the courthouse. The attorney's role is to advocate for your interest, whatever they may be, But but make sure you listen to the mediator, because you can really learn a lot about what the other side is saying, and you can really, understand your potential weaknesses in your case.
Yeah, it's absolute art form, Brian, to listen to what the mediator comes back into your room and says after having caucused with the other side, to give you insights. And a smart, good, competent lawyer is really going to give you that insightful advice to help guide you to reach a good agreement. That maybe you don't like all the provisions, but that usually means it's a good agreement if everybody comes out a little unhappy. The other thing I would tell you, so like people will say, okay, well, why I feel like I would just want to go to trial. I want my day in court. Okay. And so I don't know about going to mediation. Now, what are you seeing, Brian, about like cost advantages of mediation? I mean, is that something that you would?
Well, I would
you'd
say
advise clients?
I would say trial cost at least, I'd say on a good day, probably 5 times what a mediation will cost. And understand that the way that the courts work in Texas, it's not like a TV show, and it's not like, a TV show where you get your day in court, you're the only one there, and the judge is hearing you and getting your full attention. The
Brian,
judge
you
has.
saying it's not going to be like OJ? You're not going to get like a 3-month trial to tell your
No,
whole side of the story?
I had a really, really good lawyer, and actually this guy was a former judge, telling me that when you get into court, if you need a full day, you're going to get a half day. If you need a half day, you're going to get 2 hours. If you need a week, you're going to get 3 days. That's kind of the bog down of the system. Here's the other problem. I once had a trial in a court where we went back 6 times on 6 different days over the span of 2 months. And you want to talk about how that trial was, just parsed, and then it took another 2 months to get a decision. So that went on for about 5 months, and it was so disjointed. We were an afternoon here, a morning there, and then we'd wait 2 weeks and then come back and we had a full day. And then the last day we ended up going all afternoon and into the evening. And, the clients really walked away with this kind of a sour taste in their mouth just over the process alone, because, they didn't feel like, that they were really heard. I promise you the judge was a very, very good judge and heard everything that was going on in the case. But they didn't feel like they were listened to because it was spread out over a long period of time. You're not going to get these Hollywood versions of trial where you're in there, there's nobody bothering the judge, they got your full attention, and the judge is into it and knows exactly what you're talking about. Sometimes the judges have heard 100 cases before yours, and they consider it similar to what they've heard before. So you've got to really consider all of those things.
Yeah, I mean, the sad part of the situation, and I try to tell clients about the cost, is because people, we've said this before. Going to court and fighting is like playing the sport of polo. Right? Sport of Kings, super expensive to play that game. It is super expensive to fight in court. You've just spent a lot of money going through the discovery process to gather documents, to gather information, to marshal your case, to potentially go to trial. At this point, everybody gets a dose of reality, because you'll have just seen that huge legal bill and said, wow, whatever it was, if it cost you $50,000, it cost you $5,000. Whatever the size of your estate, it's going to take a chunk of it to get ready to go to trial. And that's not the expensive trial. So that's just the getting ready, so that I know what's out there, so that I can be prepared to go to mediation. If I can't settle it, then I'm absolutely going to go to trial, which will be the next podcast that we talk about. But in this situation, you absolutely have an opportunity to stop the hemorrhaging. You have an opportunity to be realistic, to go in, and really work with the other side to minimize your exposure and minimize your expense. That's what mediation really affords people the opportunity to do if they're willing to take it.
Plus the emotional cost. And I will tell you this, and this is, I would take this with me to my grave, that if you end up duking it out in the courthouse, and you're going to have to bring your best case when you go to the courthouse and say a lot of negative things about the other person, and the other person's going to say a lot of negative things about you, you will not be speaking to that other person when you walk out of that courtroom. The good thing about a mediation is that it does afford you the opportunity to sometimes part as friends. And at least, especially when you've got children, and especially when you're trying to work out a co-parenting relationship.
Yeah, that's a great point, Brian, because, as much as we'll tell people, they're like, I just got to have my day in court. I want somebody to hear all the bad stuff that she did to me and admonish her and just tell her what a terrible person she is. That's really not a court's job, and that's really not going to be the process that you're going to get out of that whole situation. You're going to get a big expense, a big bill. And you're definitely going to get probably an enemy that's going to come out of there with somebody that if their kids involved, especially, you're definitely going to have to co-parent with that individual for a long period of time. So think of that.
And keep in mind that if you get the short end of the stick, you're gonna be licking your wounds and biding your time for the next time when you can get back in court and show that you're not the monster they made you out to be.
Oh, yeah, without a doubt, Brian. You're sitting there and you're going like, wow, you mean like that's the decision that the judge made? And you're like, yeah, but what are my options? Spend a lot of money appealing it. But in relation to this topic, I guess, so you either settle informally, you settle mediation, as we wrap up this portion of it, Brian, what advice would you give a client as they contemplate or consider mediation, regardless of what point of their case that they're in?
I would tell you that, if you get the opportunity to go to mediation, it's a good thing and it can't hurt, and there's a good chance you can get your case resolved. But I think it's just like anything else. I think you do have to go in there prepared. I think you do have to game plan out different scenarios. I think you do have to, look at, because you have to look at it this way. I mean, I always tell people that if you have a list of 10 things, you may not get all 10 things. You may get 7 of them. You may get 8 of them. You may get 6 of them. Can you live with getting 6 of the 10 top 10 things that you wanted? Can you live with getting 7 or 8 of the top 10 things that you wanted? You're probably not going to get all 10, and the other side's not going to get all 10 either. So a mediation is going to be a compromise. So what you got to kind of game plan out is, okay, on my list of priorities, whether it be custody, property, whatever it is, this is most important to me. This is non-negotiable. This is negotiable. And have that come in your mind going back and forth as you go through this process.
Yeah, I would echo those sentiments. Well, that is all we have for today. Stay tuned, because obviously we're going to come back and we're going to talk about the big granddaddy of them all, trial on our next one.
The trial, the absolute trial, the biggest thing that we do, and as divorce lawyers, and the thing that can have probably the biggest impact on your life, would be a trial where a judge or a jury is making a decision on your life. So stay tuned for that. We have that coming up next. And if you want to get in contact with us, just reach out to us. Our website is www.astxlegal.com, and we'll be happy to assist you.
Yep. Well, until next time, Brian, as always, stay safe and well, my friend, and I'll talk at you soon.
Yes, sir. Take care of you and yours.
Thank you for listening, and we hope you enjoyed the Top Texas Lawyers podcast. If you would like a consultation with either Bryan or Sam, please call 1-888-981-7509 or visit us on the web at astxlegal.com. Once again, that's astxlegal.com. Thank you very much.